So dear students and also dear online participants, welcome to already the 10th lecture to our lecture series on strengthening EU environmental law. So I'm very pleased to introduce two speakers today. One is present here on site, Professor Ellen Vos, and the other one is present online, Dr. Annalisa Volpato. And they together have contributed to the research handbook on EU environmental law with a chapter on the role of agencies in EU environmental law. And this is super important since EU agencies play an increasingly important role in the field of environmental law and in environmentally sensitive domains. Their lecture will focus on how agencies contribute to integrating environmental concerns in EU governance and administration. And without further ado, I give the floor to you, Ellen, and you will cover the first part of the lecture, after which Annalisa will follow. So Ellen, there you go.
Thank you very much. Thank you very much, Marianne, for this kind words and for the invitation. Just look a bit at my notes. So it's a great honor for us, for Annalisa and myself, to be here and to address a topic that we both, in fact, are very expert in, I can say, agencies that we have studied for some years. And in fact, it was specifically on the request of Marianne to write, in fact, a specific article on the role of agencies in environmental protection. And we discovered actually that there is one European Environment Agency, but there are actually much more agencies that are concerned with environmental issues. So we have our slides organized that, yes, thank you very much, that Annalisa is administering these slides from Padova. So this is the overview of what we're going to deal with today. And the main question, in fact, that we address today is the role of EU agencies in environmental protection. And I'm not going to just read out the overview. It's nicely written here on the slide. And we will also say something specifically then about the implementation of the Green Deal. Next. So as others, next. Yes, thank you. So there's a whole series that you have been dealing with, Marianne, in this wonderful lecture series on the European Green Deal. And we're not going to talk about these issues, but we thought this was a wonderful slide, in fact, giving expression to the many policy fields, in fact, that the Green Deal is touching upon. And if you look to these policy areas, we, from an agency perspective, so putting on the spectacles of European agencies, we immediately see that in many of these fields, agencies operate. So we can see European Food Safety Authority in the field of agriculture, climate, the European Environment Agencies, but not only, and we will discuss that as well, the European Aviation Safety Agencies for Transport and Railway Agency, and also the European Energies Agency, the European Agency for Cooperation of Energy Regulators. We will come back to these agencies later. And in fact, these agencies collect information, they give scientific advice to the institutions and prepare guidelines and issue certificates. Now, before going into the specifics of what these agencies do in the field of the environment, environmental law and policy, we would first like to explain what agencies are. Next. And the rationale also we will explain, and what, in fact, these issues give kind of problems to in terms of legal perspective. So what now are agencies? How can we define, in fact, agencies? And in this lecture, we will talk only about EU decentralized agencies, as the Commission has termed them, and not about executive agencies. That's another story, and we're not going to deal with them in this lecture. So what are these EU agencies? Well, we can define them as bodies that have been created by the EU legislator and that have their own internal, not international legal personality, but internal legal personality. They are independent, or maybe better said, autonomous. And they're financially independent in the sense that they have their own budget, but most of these agencies actually are dependent on EU subsidies, so the EU budget in general. They have a limited mandate and most often operate mostly in the executive function. So these agencies have been delegated specific tasks and have or do not have decision-making powers. Next. So these agencies that are created by the EU legislator operate in various policy fields, and they have become a very important feature of the EU's institutional landscape. Actually, it's said also in the literature, the EU could simply not function anymore without its agencies. And it's also something what is said in literature, that these agencies operate at an arm's length of the European Commission. And some of these agencies are based on existing committees. They're taking out the responsibility of which is taken out of the Commission and put at an arm's length distance of the European Commission. They have had their own legal personality. So, in fact, we can say that these agencies fulfill actually a kind of double decentralization. So they have a functional decentralization because they carry out functions that are public function, that are delegated by the EU legislator to them. So that's what we constitutional, institutional terms is called decentralization of functions and tasks. And also from a geographical perspective, they're also decentralized because unlike the EU institutions, you find these EU agencies all over the European Union. Next. So the rationales for creating these agencies are manifold. We can signal that most of these agencies actually respond to crisis and are aimed at enhancing or restoring public trust in EU acts and policies. Clear examples thereof are the creation of the European Food Safety Authority in the aftermath of the BSE crisis, the mad cow crisis. Some of you may have read about it. I don't think you have lived that crisis, or at least not consciously. And the creation of the European Supervisory Authorities to address the financial crisis. Next. So agency may also help to implement EU policies, and it could be advantageous to create an agency because this could potentially help also and be favorable for participation of stakeholders or even citizens. They're also more visible to the citizens so that people in fact could go maybe to an agency for questions that they would have. Another reason also is, that is also accounted for in the literature, especially political science literature, is that member states at times have preferred to delegate powers to an EU agency rather than, for example, to the European Commission. And why so? Because actually the whole institutional setting of an agency is such that member states, representative member states, are in the management boards of these agencies. So although they do not interfere with maybe the technical task that an agency may have, because these are carried out by various organs of an agency, but management, the member states in the management board steer, in fact, the agency, dictate the program of an agency, budget, etc. Next. So, since already the case law of the Court of Justice at the end of the 1950s, the so-called Moroni cases, legal doctrine and practice have argued that the EU legislator can delegate powers as to agencies, as long as these powers are strictly circumscribed executive powers. And as long as this is so this would namely be done in accordance with the institutional balance of powers. So if in fact these powers would be discretionary, so whether there would be a discretion for an agency to decide to allow, for example, a product on the market, this would be a discretion that would, according also to this case law, not be in accordance with the institutional balance, as this is a task for the Commission to carry out. Next. So the operation of these institutions still rise to various problematic issues, at least from a legal perspective. And I have accounted 4 that I will discuss in this lecture. So judicial review as a constitutional, neglect in the executive rulemaking, the delegation of discretionary power, because as I just explained, it was not allowed by the legal doctrine from the Moroni case law since the 1950s, but recently there has been some movement in that area, and we're going to look at that. And also independence, that is specifically also important for agencies that would collect information, but also give scientific advice, which could be of importance for the environmental policy. Next, please. So as regards judicial review, so it seems now that the Lisbon, that in fact quite clear, because we have since Lisbon an article that gives expression to the possibility to review agency acts. And before Lisbon, actually, this was practice, but it was not formally codified in the treaty. So we had the European Court of Justice accepting jurisdiction for an litigation against an agency act that registered a trademark, that had refused, in fact, to register a trademark. That agency act was then challenged before the General Court, and the jurisdiction was accepted, but it was not written in the treaty. So the Lisbon Treaty actually codified an ongoing practice. And it is written in the treaty that, in fact, Agencies Act can be challenged, but only those that intend to produce legal effect vis-à-vis third parties. So judicial review cannot be enacted for preparatory acts. So, for example, not for a scientific advice given by a European agency, for example, the Food Agency. So in the rather recent case of 2 years ago or 3 years ago, in the FBF case, so what was it now? The Federal Fédération Bancaire Française, in fact, the Court of Justice also appeared, very interestingly, to be ready to review also guidelines of the European Banking Authority that are formally non-binding. However, in fact, the Court of Justice appears to apply the same principles of this non-delegation vis-à-vis the discretionary powers to also to these guidelines, so formally extending judicial review of the European Banking Authority soft law powers. Next. A second potential problematic issue is that although the Lisbon Treaty finally acknowledged the existence of agencies throughout many treaty articles, so the agencies already exist, created by the EU legislator since the 1970s. However, the word agency you could not see in the treaties before the Lisbon Treaty. The Lisbon Treaty finally acknowledges that agencies are there, introduces them in many treaty articles, as we have seen also the Article 263. However, it does not, in fact, acknowledge that powers can be delegated to European agencies and that these agencies can adopt binding acts of an executive nature. So reference to EU agencies lacks where you would expect it most, namely Article 291. At the same time, so in fact, but we see that, so there's not formally possible to delegate powers to agencies, apparently, but also and in fact, you see that 263 acknowledges that agencies can adopt kind of executive decisions. Next. So this issue about the constitutional neglect and discretionary powers, in fact, came up in a long-awaited judgment about the delegation of powers to an agency, namely the ESMA or the short-selling case. That was put before the court by the UK, and it was, in fact, about the UK challenged a regulation that delegated a specific power to this ESMA, to the European Securities and Market Authorities, namely ESMA's powers to intervene under certain conditions through legally binding acts in the financial markets of member states where there is a threat to the orderly functioning and integrity of financial markets or to the stability of the whole or part of the financial system in the Union. Next. The UK challenged this provision on 3 points. It said, well, this, in fact, provision is not in accordance with the current delegation of powers doctrine, namely not the prohibition to delegate discretionary powers to agencies. It also, in fact, is not compatible with the system of executive non-legislative powers that is laid down in Article 290, 291. And in fact, the system is not compatible with the principle of conferral of powers in relation to Article 114. I will go into more detail into the first 2 points. Next. Yeah. So here the court in this case expressly confirmed existing of the Moroni doctrine or the limited delegation principle. Agencies cannot be delegated discretionary power. However, at the same time, the court acknowledged that some discretion actually is possible for agencies, for powers to be delegated to agencies. And so the court, in fact, appeared to be much more lenient in practice, although it firmly says no discretionary powers can be delegated. And the court is a bit more lenient, and that's important is here the fact that ESMA is an agency that is created by the EU legislator. For the court, that's fundamental. Moreover, these powers that are delegated were circumscribed by various conditions and criteria that limited ESMA's discretion, acknowledging that ESMA has discretion, but at least a limited one. So, in fact, the court concluded that that is possible to delegate these kind of powers. And key for the Court of Justice was also that actually there is judicial review possible against acts that would then be adopted by ESMA. And also the FBF judgment that I just mentioned also confirms that a bit of the opening up of the courts to agencies having more discretionary powers. Next. The second then, in fact, the court appears to be willing to repair the constitutional gap by considering, in fact, that Articles 290 and 291 are not the only articles that govern the executive powers, and that, in fact, powers that have of a binding nature, to adopt decision of the binding nature, can be delegated to EU agencies. Next. A last issue that I would like to address concerns the independence of agencies. How can agency be independent, but yet under control? Because in fact, agencies also are independent, but should also be under control, because the EU legislature, but especially and the other institutions, do want to know what these agencies do and want, in fact, to be able to some extent, steer them. So this issue of independence is particularly relevant for agencies that issue scientific advice. So what is independence? So we say that is a status which ensures that the body concerned can act completely freely without taking any instructions or being put under any pressure. So this refers and includes various types of independence. So institutional, referring more to the organizational, budgetary, and staffing and financial. And I already have noted that that's financially, most of the agencies are dependent actually on the budgets of the EU, and the functional independence. Now, on request of the European Parliament and the Commission, agencies have organized their own rules, in fact, on the conflicts of interest, in fact, where they regulate in particular the absence or the limitation of commercial interest of the members of their internal bodies. Different item, however, is in how far members of organs of agencies should also be independent from member states. Next. So this was a very brief overview of what agencies are, and we would like now to dive into more detail of what these agencies do in the field of environmental protection. Next. Next. There are some, missing. Okay, yes. So we see there's a variety of agencies that we also studied in our article, which evidently have a role to play in environmental law and policy, which is first of all the European Environment Agency, but also the aviation safety, the fisheries, the maritime safety, the European Food Safety Authority, the chemicals agencies, and the European Medicines Agency. But also, in fact, other agencies deal with these environmental issues.
Thank you, Ellen. Indeed, I think that the audience is now wondering what concretely do these agencies to pursue these objectives. We know what they are, we know which agencies are active there. We have seen the different logos of the agencies, but what do they concretely do to achieve this objective? Well, from a mapping of the tasks performed in connection to environmental protection, we can see that there are roughly three groups of relevant tasks: information gathering, inspection and certification functions, and environmental risk assessments. First, with regard to information tasks, this is clearly the main task of the European environmental agencies that Ellen mentioned, which is there to provide objective information to EU institutions and member states, which is necessary then for framing and implementing sound and effective environmental policies. It does so by collating and assessing data on the state of the environment in Europe. So on the quality, on the pressures, on the sensitivity of environment in Europe. And it collects this data mainly through the so-called European Environment Information and Observation Network, which is a network of national authorities, which are each competent to collect information on the state of the environment in their own country. So EEA gathers this data and then issues reports, which can be ad hoc on specific issues or a general one every 5 years on the state of the environment in Europe. It also disseminates this data to the broader public. So in fact, you can find these reports in the EEA website online. The task of collecting information about the environment performed by EEA is actually performed by other agencies too. agencies especially specialized on specific sectors, such as aviation or maritime safety. However, what is interesting is that, different from EDA, these agencies also perform a second set of tasks which are relevant for environmental protection, and that are actually more incisive than just information gathering. In particular, the European Aviation Safety Agency, EASA, so to speak, issues the certificates which are required for the design of aircraft and their components. So before issuing a certificate for a certain design, it verifies not only the safety and the airworthiness of that design, but also its compliance with noise and emission standards which are enforced. So with aspects which are important for the environmental protection in this specific area. On the other hand, the European Maritime Safety Agency and the European Fisheries Control Agency are empowered to carry out control tasks by doing inspections on national administrations, port facilities, ships, shipping companies, to check whether or not they comply EMSA with the relevant rules against maritime pollution, and EFCA with the regulation on sustainable fishing, so all the limits on catching and so on. Finally, there are also agencies whose task is to carry out a scientific assessment of the risks that certain products or substances may pose to the life and health of persons, animals, and plants. So, the European Food Safety Authority for Food and Feedstuff, European Chemicals Agencies for chemicals and substances, chemical substances, and the European Medicine Agency for medicinal products for veterinarian and human use, they all are tasked with by specific regulations to provide an identification and an evaluation of the effects of certain products also on the environment. And this evaluation is then included in an opinion of the agencies, which forms the basis for the European Commission to decide on whether or not to allow the marketing of that product in the internal market. So you see, it is clear that through different tasks and roles, EU agencies play an important role in support of environmental policy and in support of the objective of environmental protection. The question is now, how did this change after the European Green Deal? What is the role of EU agencies specifically in support of this major policy initiative? Well, from a general perspective, we can say that there's a clear continuity in the functions and the role of EU agencies in the implementation of EU environmental policy before and after the European Green Deal. EU agencies continue to perform the tasks that we have described so far. So the same powers and with the same powers and the same limits. For certain agencies, however, in addition to what we have said, specific measures, like the ones contained in the Fit for 55 package, have added new tasks, new competencies in their mandate. For example, this is the case, for instance, of EASA. We already mentioned the Aviation Agency, which under the Refuel EU Aviation Regulation has been entrusted with the monitoring and reporting of the new obligations introduced by that regulation about the use of fuel and by aircraft operators and aviation fuel suppliers. And also with the management of implementation and enforcement of a voluntary labeling scheme established by that regulation. Moreover, we can see that in many working plans and strategies adopted by EU agencies after the European Green Deal, there is a special attention and a reflection on how to adapt and incorporate the objectives and the policies of the Green Deal in their specific sector. So it's a self-reflection exercise exercise if you want. For instance, in the EFSA strategy for 2027, there's a specific section on how to implement the Green Deal, and specifically the farm to fork strategy, which is a specific strategy which concerning food chain and food and feed production, which is a sub-strategy of the European Green Deal. It's part of the Green Deal. Well, so in that context, EFSA is further elaborating, for instance, the concept of one health, one environment, which derives from these, environmental objectives included in the food chain strategy, and it is rethinking its working methods in this perspective. So, like planning to systematically include environmental considerations in the risk assessment that it adopts. So, creating a sort of, or adopting what is called an integrated risk assessment, which would include an assessment of the environmental impact of food, products, and substances in each kind of evaluation of the product. So it is an evaluation of all the aspects of this product, including the environmental one, in a combined way, which is not the case so far. Of course, this is still work in progress. It's not yet enforced and not adopted as a practice by EFSA, but it shows the impact that the Green Deal has had on the globality, the entire kind of work that EU agencies perform. Then, for obvious reason related to its competence and its expertise, the agencies that more than anyone else is at the front line in the implementation of a Green Deal is certainly the European environmental agencies. And here again, we can see the continuity in the functions and tasks performed by EEA in relation to the environment. However, also here, we see additional tasks conferred. In particular, the European climate climate law, which I think at this point of the lecture series you are well familiar with, it expressly requires EEA to assist the European Commission in the assessment of Union progress in achieving the environmental objectives and the consistency of Union measures with the climate neutrality objective of the European Green Deal. It also tasks the EEA to help the Commission to assess the national measures on this. Similarly, in the regulation on the governance of the Energy Union and climate action, it provides for a role of EEA in the assessment, monitoring, and reporting of member states' policies and measures on decarbonization and energy efficiency. So, in practice, EEA has to compile the information reported by the member states on these issues, control their quality and their trustworthiness and their consistency, and this to maintain and update a database on member states' mitigation policies and measures, which are then available to the EU institutions, in particular to the European Commission, to assess then what is the progress of the Union and what the member states are doing. So, as you can see then, the role of EEA in the assistance of the European Commission is enhanced. So it reaches activities and topics which were not previously in its mandate, in this incremental, let's say, role that the European Green Deal has had on the tasks of EU agencies. So somehow the scope of its activities is expanded. However, if you look closely, the actual powers, the kind of powers that it can exercise are actually the same. It's all information gathering. It is still collecting and compiling data on the state of certain aspects of the environment or on the national measures adopted. So it is compiling data on the factual situations there. From the wording of the provision, it is very clear that that it compiles existing data, but it does not carry out scientific studies, nor scientific literature reviews. It is also clear that its role is in assistance of the Commission, which is the one that actually adopts these assessments, which takes the decisions. And EEA does not have a specific role in, it doesn't give a specific advice on concrete decisions that have to be taken by the Commission concerning the environment. What it is interesting, however, is that in the European climate law, there is a EU body which does some of these things that the EEA is not doing. And this is the European Advisory Board on Climate Change. What is this? Well, it's a new body established by the European climate law itself in Article 3. And it was adopted owing to the Parliament demands actually during the negotiations. So it was the Parliament pushing for the creation of this specific body. And it has different tasks. Particular among its tasks, it is very specifically the one to consider the latest scientific findings of the IPCC, which is an international body on climate change, its reports, but also scientific climate data, which becomes available. It has to contribute to exchange of independent scientific knowledge, and also, which I find it quite remarkable, that it also can also identify concrete actions and measures for the achievement of the Green Deal targets, and so give specific scientific advice. As I told you, this is a new body, and this is a different body from the EEA. A different logo, different mandate, different rules of procedure. It's something else. But it's at the same time, it's clearly linked to EEA. The regulation explicitly says that its work should be complementary to EEA, whatever that means. In fact, the Secretariat of the Advisory Board is hosted by EEA, and the budget is actually included in the budget of EEA. This Advisory Board, in fact, is composed by 15 senior scientific experts on different disciplines, actually, designated by the Management Board of EEA, according to an open selection procedure, but still. And their mandate is for 4 years. The Article 3 of the European climate law is very, very clear in requiring full independence of these experts. And they must act independently from the member states, from the EU institutions, and also by EEA. But we just said that there are strong ties between EEA and the Advisory Board. So this relationship is somehow unclear. The independence of the experts obviously includes also independence vis-à-vis private parties, private interests, so the industry. However, to us, it's not very clear how it works in practice, because since the Advisory Board is not part of the European Commission and also not part of EEA, nor an independent agency in itself, it is clearly not covered by the specific rules on conflicts of interest that Ellen was mentioning. So it's not covered by the, for instance, the Commission staff regulation or the guidelines for EU agencies on conflicts of interest. So it is not clearly within the scope of that legal framework. What we can find is that there's an obligation to file a declaration of interest by these experts in the rules of procedure of the Advisory Board itself, but it is not specified who is going to monitor and enforce on this declaration on independence if there are, possible violations or false declarations. Moreover, this emphasis of independence, which we have already seen with Ellen, that it is a core issue and a problematic issue with EU agencies in general, here with the Advisory Board is not clearly put in a context, it's not counterbalanced by, provisions on the accountability of these experts which somehow would, counterbalance this tension. This aspect is left vague by the regulation, and is something that is still certainly worth developing and exploring in this aspect on this. So all in all things considered, this European Advisory Board on Climate Change, from an institutional perspective, is a strange beast. It is not really an agency, as it does not fit the definition of EU agencies that Ellen gave us before, but at the same time is much more than just a group of experts. It's much more than just an advisory committee, like the ones that the European Commission generally it can establish, and it uses them to receive input for proposals and general policies. I'm referring in particular to things like the scientific advice mechanism or the scientific committee on health, environment, and emerging risks, which are quite and function quite differently from this advisory board. It works at the same time as a scientific advisor, yes, I agree, but at the same time, it's also a watchdog of the effectiveness and consistencies of the EU and national decarbonization policies. It also engages with science, reviewing and disseminating scientific knowledge. And finally, it can also act as a driver for policy initiatives, feeding the Commission on the way forward in climate change issues. Clearly, its concrete role and identity will become more clear as we go. It will depend on how it will exercise its powers in practice. What we can already see now is that its advice has an impact on the Commission's work. Its last advice, for instance, was clearly the basis, and explicitly so, of the recent Commission recommendation for 2040 emission reduction target. So it has an impact on EU environmental policy. And from a broader perspective, we can also wonder what this means for the agencyfication and the agency model as such. The decision to create a separate body instead of, for further empowering EEA, for instance, and a body which exercises functions which are typically of EU agencies without being an agency, fully fledged agency, I mean. Is it the sign of a crisis of a model, of the agency model, or is it just a reasonable solution for the specificities of this policy area? And in this, I have to say that actually we can arguably see it happening also in other fields. So I would be inclined more to the first answer, because, for instance, after the COVID-19 crisis in health, we had the establishment of HERA, which is within the European Commission and not really an agency. We have now the Artificial Intelligence Office, which is going to be created. So there are signs here and there of this kind of escape from the agency model. And, this advisory board is maybe interesting also for this, also from this dimension. And actually, maybe the last word on this has not been yet spoken. There is a European Citizen Initiative at the moment open on this, open for signature, which actually aims at reforming all this. They propose to replace the existing European Environmental Agency with a European Environmental Authority with much more effective powers. In particular, the power to adopt decisions vis-à-vis member states and natural and legal persons which do not comply with environmental rules established by EU law. So, for instance, adopt fines for companies which pollute and so on. Although this might sound appealing, in comparison to the rather weak powers of EEA at the moment, we know by now, as Ellen explained, that there are certain legal limits to the empowerment of EU agencies. And the possible mandate of this authority, for sure, will need to comply with the Maroni Doctrine 2.0, but still. So, and it also needs to have clear guarantees of, limitation of its powers and accountability. So in that sense, any reform should take into account also these aspects. So, in conclusion, in this lecture, we have seen the importance of EU agencies for EU governance and for the governance of EU environmental policy in particular. They contribute in many ways, different ways and with different tasks to the objectives of environmental protection, and even more after the European Green Deal for the achievement of a specific targets of that policy. We have also seen that this is the case not only for the European Environmental Agency, but also for other agencies which incorporate environmental protection considerations in their own specific areas. The picture here is it's very fragmented actually, even more so after the establishment of a European Advisory Board on Climate Change, whose tasks partially overlap with EEA and whose relationship with that agency, with the environmental agencies, remain somehow in the ambiguity. So, to paraphrase the famous title of an Italian writer, Pirandello, we can say that there's one, no one, and 100,000 agencies involved in the implementation of the European Green Deal. Clearly, we can question the effectiveness of their action in this fragmentation, in this overlap between the competencies, the vague relationships. Would it be better to, change EEA, strengthen its powers, giving it, more, decision-making powers, or merging it with, the advisory board, so to have one agency, one voice in this policy field, or as it was suggested by this citizens' initiative, simply completely reform the system and create a brand new agency. On this, we do not have a clear answer, but keeping in mind the characteristics of EU agencies and the limits to their powers, it is certainly a question worth discussing. So, thank you very much for your attention, and we look forward then for this discussion. Thank you.
Thank you so much, Ellen and Annalisa, and Liam quickly unmuted. So I hope, Annalisa, that you could hear the applause coming from the hall. So also personally, I really have enjoyed this lecture because this is what we really need as well, in addition to the European environmental law course we run now. Actually, it is this week that we have discussed the principle of external integration, which means that environmental requirements should be taken into consideration in other policy fields. And you show indeed how many agencies are involved in the wide field of environmental law. Moreover, we also discussed a little bit this recent recommendation that the Commission did, but referring directly to the advice from the European Scientific Advisory Board. And I have not seen yet in literature a legal analysis of this new strange beast, as you call it, in EU environmental law. So thank you so much for your analysis on such a topical topic. And having said that, perhaps a final applause before we finish the recording of this session. So thank you so much.